Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. All right, few things. If y'all hear yelling in the background, it's because my oldest son is home from college and he's on his game. And yeah, hold on, I'm about to go tell him to shut up because I ain't got time for it tonight. Okay, make sure that I set it on. Let's do this. Okay. All right. So this is going to be part two of Meg the Stallion, Megan P versus what's her name? Milagro. I hope I'm saying her not right name right. Elizabeth Cooper, aka or Milagro Grams. Some of that sort. Something of that sorts. Okay. Hold on, because I'm just making sure that I have my subscriber. What's up, Buttercup? What up? What up? What up? I don't know why two of this is showing up on my hold on, let me check something. Oh, okay. This is weird. Cause it's like, why isn't my thumbnail from last night showing? Good evening, Miss Bugs. Okay, that's good. That's good because let me tell y'all something. I miss my child when he's off to college, but when he comes home and hop on the game, I'm like, bro. And then my youngest one, he's getting sick. He has a little cold, so I had to take care of them before I even came on here. Hold on, because I want to make sure my thumbnail, I don't like. So I use Restream, and for some reason, it created two entries on here. Let me see, Megan the Stallion. Definitely put my freaking thumbnail up here. All right, so that's that. Hold on, I'm just trying to do some making sure that's good, that's good, that's good. Save that. And then here, there we go. Yeah, that's weird that it did that. Okay, so we're all set. So if you was with me last night, you know that the amended petition was filed, I believe a couple of days ago, but Megan ended up adding defamation and a few other things to the lawsuit. Prior to that, Milagro, I hope I'm saying her name, or I'm just gonna call her Miss Cooper. She ended up filing a motion to thank you, Miss Bug. I will let him know. Yeah, so my youngest two were like, oh my god, I'm so happy he's home. I have all boys, they're so awesome. Um so going back to Megan, so Milagro, she ended up filing a motion to dismiss, and in that motion to dismiss, she was pretty much stating that the first complaint that Megan filed, it didn't state a claim, and she didn't have any jurisdiction, blase blase. And so Megan went ahead and filed the second, or not the second, well, the amended petition, and in that petition, she states exactly why she filed in the state of Florida. Just to kind of sum it up, it was because if we think about YouTube or any type of social media, you don't just have an audience in your state that you're in. You have an audience pretty much everywhere around the globe. So due to the analytics that the attorney was able to review, majority, and so Megan, she has residency in Florida. She has a driver's license. Her dogs stay there when she leaves. So everything is Florida based. Her businesses is out of Florida. And so when the incidents happened, it happened when she was in Florida. So that goes to the viewers that were on Milagro's YouTube, Instagram, whatever social media, majority of them were in Florida. And so that was the reason as to why they filed in Florida versus actually filing in Texas where Milagro lives. So I am going to pull up this complaint. Alrighty, I'm gonna close a few things out because get rid of my emails. Oh, that's probably why I already had a restream up. I was wondering why it was showing two. All right, and I think I remember where I left off at. So we read a little bit about the defamation. The defamation. Now let me blow this up so you guys can see it. I think that's good enough. Okay, so let me go down to page 23. So we pretty much, if we followed the trial, I didn't follow the trial. I'm going to be honest with you guys. I just kind of went on different channels to see like a quick notes because I wasn't going to go sit through all that trying to figure out what's going on. Okay. So I believe I left off over here. So we're going to start with her defamatory statements because mind you, she ended up, so I'm at page 22. Let me see, because in this particular type of petition, no, it doesn't show it, but that's all right. So the first part is the defamation part. So the defamation, yeah, we read that part. 1920. Okay, so defendants' defamatory statements were made with actual malice, because that's the biggest thing there. A lot of people was like, "Well, we know she said what she said, but did it cause any harm?" Blasey, blasey, blasey. In which it did, and look where we're at now. So defendant acted with actual malice because she made her defamatory statements with knowledge of and or reckless disregard for the falsity of these statements. Indeed, even after the jury found Mr. Peterson guilty beyond a reasonable doubt of shooting or pow-powing Ms. Pete on December 23rd, 2022, defendant, who was fully aware of the guilty verdict, continued to falsely accuse Ms. Pete or having lied under oath about whether Mr. Peterson pow-powed her. Defendant did so knowing that Mr. Peterson's guilt had been established in a court of law beyond a reasonable doubt. Accordingly, defendant knew that her statements regarding Ms. Pete were false, or at the least recklessly disregarded whether they were true. So anytime you put out information, I've always said this and I say this time and time again, you have to make sure that you know what you're talking about and you're putting truth behind it and you have receipts to back that up. The fact that this girl sat at trial and listened to the jury give their verdict, she still found it to be, I guess, very profitable, um, very entertaining to still continue with the misinformation. And that's where people get in trouble at. If you knowingly know the truth and you put out false information about somebody, that is defamation. Defendant's malice in defaming Ms. Pete is also evident from the fact that she has admitted to spreading misinformation and falsehoods about Mr. Peterson's criminal act of gun violence against Ms. Pete. Defendant's falsehoods of and concerning Ms. Pete, as well as her misinformation campaign about the trial, generally reflect defendant's deep-seated ill will toward Ms. Pete and her intent on pressing a preconceived and false narrative at the behest of Mr. Peterson. Among other things, defendant has repeatedly promoted at least 3 false and debunked theories. And we went over this last night, but I want to start there. So here are the debunked theories. Her first theory was that there was no firearm recovered at the crime scene related to the trial, and if there was, the LAPD lost or misplaced it. The other false theory she put out there was that Mr. Peterson was not the person who pow-powed Miss Pete. And the third thing she put out in the atmosphere was that Miss Pete did not suffer a bullet wound as a result of Mr. Peterson's criminal assault, but rather suffered injuries as a result of stepping on broken glass. So, one, when the police even pulled him over, the pow pow was up under the seat. That was in the in the indictment. All right, in the police report, in the statement. The second thing, the LAPD already came out with a declaration stating that the Pow Pow is in their evidence room, and they have a declaration on file for that. The third thing is she went to the hospital and they pulled out gun fragments. So she knew this. She was in trial, she was present, and she heard all of these things, but yet she still decided to go on her platform and put out this information that was not true. My child. So, for example, on October 28th, 2024, defendant stated on her X account that the Pow Pow and the bullet fragments associated with the crime have gone missing. Did not tell y'all that the gun or the Pow Pow was never presented in court, and that ain't make no dang sense. They gave the serial number and breezed past it. Like, first off, whose is it? Original point, please. On October 28th, on a YouTube video that she posted to her account, she stated, "How do you hold someone in prison when you don't have a darn weapon or what was supposedly coming up out of Miss Pete's foot?" In that very same video, she also stated, "Y'all did not prove that she was pow-powed in court. You did not prove that. You don't have any bullet fragments, and now you don't have a darn gun. So you don't have anything that would prove that this actually even took place. How effing convenient." Defendant later states in her post, "The gun was collected at the scene and it was supposed to be processed. The bullet fragments were taken out at the hospital," they say. Even though, do y'all remember how long it took for charges to be raised? Them people had pulled that ish out of her foot. She done went home. That ninja didn't get charged until October. If they had pulled bullet fragments out of her foot, or if she had been stabbed, the police would have been called and a report would have been filed that very moment. That's not odd to anybody. That don't even make no darn sense. Let's go ahead and pull up the receipt, people. No pow pow. So this is what she this is everything she stated. Now mind y'all, if y'all was not here last night, she has already came out and stated that she is guilty of spreading misinformation. And I need to go back and find that, but it is stated in this complaint. And the reason why I'm sure this late in the game they have probably had depositions, and I hope I can get my hands on a deposition transcript because I want to know exactly what she said in deposition. Because anybody could say anything on YouTube that they did or didn't say, but when it comes to the deposition transcripts, because you are under oath at those depots, you got to tell the truth, and if you don't, you can get in trouble. Exactly. Even his attorney, defense attorney, agrees she got popped. Yeah, this is crazy. In a separate video posted on that same day to her X account, defendant stated, "Can you even prove that you was pow-powed? None of the defendant's statements above are true. A firearm was recovered at the crime scene related to the trial, and it remains in the custody of the LAPD. Indeed, the senior property officer of the LAPD Evidence and Property Management Division confirmed in a sworn declaration in opposition to Mr. Peterson's writ of habeas corpus that the firearm remains in custody." Because if y'all don't know, Tory Lanez filed not one but two writ of habeas corpuses, pretty much saying, y'all need to get me out of here. I don't need to be in here. Y'all put me in here for no reason. There's no evidence. There's no pow pow, nothing. And so that's why the senior property officer had to come out with a sworn declaration to debunk that theory that has been spreaded across America. Let me see. Defendant could have easily verified this information, but choose to ignore it and instead promulgated lies about the integrity of Miss Pete's testimony at trial and the criminal investigation into Mr. Peterson. The same is true for defendant's blatant misstatements regarding Mr. Pete's injury. I'm sorry, Miss Pete's injury. Time and time again, it has been proven that Miss Pete suffered a pow pow wound to her foot committed by Mr. Peterson and did not injure herself by stepping on broken glass. Rather than acknowledging that fact, defendant has doubled down on her false theory and repeatedly published misstatements to her tens of thousands of fans across the social media accounts. Indeed, a December 23rd, 2022 Los Angeles Times article noted that defendants showed no remorse for pushing the Megan might have stepped on glass theory long after the surgeon had found a bullet fragment in her foot. This is how misinformation gets out there, and this is how these people are getting in trouble. Specifically, these content creators. So they can get you on defamation, as you can see. If you're putting out false information without doing your due diligence and confirming that stuff, and you're putting it out there for everybody to consume and run with their own narrative, that's defamation. If you know the truth, but you continue to put out false information about somebody, that's defamation. So you have to be careful, especially on this internet. It will get you in trouble. Nobody wants to sit there and go through lawsuits. But sometimes you got to make an example out of people because enough is enough at the end of the day. Oh my, hold on. This little boy. This crazy boy. It was not until after the suit was filed that on November 19, 2024, defendant for the first time, y'all hear this? November 19th, 2024, defendant for the first time admitted the falsity of these statements and shared the truth with her followers, stating, from this day forward, today is November 19th, and the public has been aware of this form. I have to acknowledge that the pow pow, the bullet fragments, the magazine, and the bullet casings are with the LAPD. The form defendant referred to is the October 31st, 2024 declaration of Martin Perciado, who is the senior property officer of the LAPD's Evidence and Property Management Division, submitted in support of the California Attorney General's opposition to Mr. Peterson's writ of habeas corpus. Mr. Preciado's declaration affirmed under oath that the LAPD's Evidence and Property Management Division has the firearm magazine, and all the bullet casings and the bullet fragments that were booked in connection with Mr. Peterson's trial. Defendant should have already known this information to be true because it is consistent with the testimony defendant heard at trial, wherein multiple experts, such as a doctor who operated on Miss Pete on the night Mr. Peterson powed her, and multiple forensic experts confirmed the use of a firearm in the presence of bullet fragments in Miss Pete's foot. A lot of people don't know. Well, I'm pretty sure if you watch like these law shows and stuff like that, you will see expert witnesses. Okay, expert witnesses in whatever capacity they need to be in. If we're disputing like medical records, then you'll have a doctor up there, or it just depends what type of doctor. If you're talking about forensics, then you'll have a forensic specialist. So for Cooper to be in trial, listening to all of these experts, listening to the doctor say, I'm the one who operated on her foot, I'm the one who pulled out the bullet fragments, she still decided to go and spread misinformation. Do you have that much hatred for a person that you are willing to continue to spread false information, lies? And people are brainwashed to actually sit there and believe it. Everything that and I don't want to say everything because everything on the internet is not true. But if you're wanting to talk about court cases, something in a trial, something of this nature, you can pull these documents and you can read for yourself. It is public records. Majority of criminal records are public records. The only thing that you won't be able to see anywhere, I haven't found it yet, is a family law case. Because especially if you're dealing with kids or children, their information is personal. Or if somebody requests for their records to be sealed, then you won't have access to it. But other than that, majority of the criminal records is obtainable. It's public records. So because she knows she can go verify that information. But what's sad is you were sitting there in trial and you went through the whole trial till they gave the verdict and you still came on social media and you put out false information. And look where it landed you. So it took to November 19th for you to come out and say, okay, they do have the weapon. They do have the bullet fragments. I really don't feel sorry for her. Let's see. Our 82 says the defendant acted with actual malice because she promoted her false and defamatory statements due to her relationship with the Petersons, wherein she acted as a spokesperson to spread misinformation on behalf of Mr. Peterson while he serves his 10-year prison sentence for criminally assaulting Miss P. I want to know, are they paying for you a lawyer? If that's the case. Buttercup says, mind you, Tori and Milagro was doing the whole crusade against Megan. Kind of. I like Meg the reporter. She's awesome because she was being a responsible and sharing every detail. She was, and she still does. She is awesome. She is really awesome. They better go on somewhere. Defendant further demonstrated actual malice by publishing and reiterating the false and defamatory statements out of pure hatred for Miss Pete. What I tell y'all, when somebody really really hates you, they don't care. They don't care about the truth. They do not care about the truth. Defendant's former best friend King Noor noted that defendant has a disdain for Megan. Defendant also refused to cease making her false and defamatory statements after Ms. Pete publicly and repeatedly pleaded on her social media for individuals like defendant to stop spreading such false misinformation. In response, defendant posts on her X account, Megan wants to know what she has to do to stop being posted on certain outlets. My suggestion would be to just get over it or just go away. And they gave a screenshot of that. Defendant published and reiterated the false and defamatory statements out of the desire to gain notoriety, generate revenues and profits for herself, and hurt Miss P emotionally and professionally. That is what it is. When you're on a hate train and you know darn well that the information you putting out there is false, you best believe, well, I believe that they're doing it to be popular. They're doing it to generate revenue, and you're doing it for profitability. But most importantly, you're doing it because you dislike a person. And that is so wrong. Your karma will come soon. You cannot sit out here and put out misinformation and the truth is right there. People are so brainwashed to that. It's crazy. Indeed, since defendant began her campaign of harassment against Ms. Pete, her social media following and online recognition has grown exponentially, resulting in massive public exposure and potential for advertisement and sponsorships. Y'all see this? The lasting impact of defendant's defamatory statements. Defendant's false and defamatory statements regarding Ms. Pete lying at the trial, as well as her mental competency and purported alcoholism, has caused and continue to cause Ms. Pete severe and substantial emotional and mental pain and suffering. Each time Ms. Pete sees media reports about the defendant's lies, she must relive the worst experience of her life, resulting in emotional pain, anguish, and suffering. As Ms. Pete expressed on social media, Imagine how I feel waking up every day seeing people lie and turn my trauma into a joke. The whole team figures out ways to create doubt with my story every week, and the media eats it up. Defendant's conduct at points during the trial pushed Miss Pete to contemplate suicide, or the S word, I should say that. As Miss Pete recently recounted publicly that she would rather live through this than to have to live with this. Oh, yeah, I'm sorry. No, she would rather not live through this than to have to live with this. Additionally, what am I reading? Additionally, defendants' false defamatory and inflammatory statements have incited large swaths of her followers to personally attack Miss Pete on social media based on defendants' lies. Let me tell you how crazy people are. So, for example, because people be diehard fans of, a hate page or call it page or a pro page, and they do the absolute most, and it doesn't make any sense. Let me see. So, for example, after the defendant falsely stated that the firearm and bullet fragments from the trial have gone missing in her October 27, 2024 X post, followers commented, and everybody who defend that lion bitch said, well, he went to jail for pow possession, but this entire time there was no pow, shaking my head. So she ain't no bullet fragment. Oh, foot ASSBITCH, but a glass fragment foot ASSBITCH. No gun or no pow, no bullets, no case. 100. This been old news. That's how I don't understand how this man was convinced, but the main evidence was missing in another X post from October 5th, 2024, wherein defendant questioned who pow Megan. Defendant's followers responded with attacks against Miss Pete, including everybody walking on eggshells around Megan because they're afraid of offending that angry black woman stereotype. Most are Rock Nation bots and bullies. Actual victims don't behave that way. Close friends in the industry peers know she's a compulsive liar. We all know she's lying. Megan was never pow. Tory lawyer clearly works for Rock Nation. Nobody believes Tory pow that horse. They mad Tory been out streaming her all year and the public still rock with him. Tell Marcus post her Spotify rap this year. I guarantee you Tory did more streams, all while being shadow banned. Meanwhile, she plastered on the front page. I don't even listen to Tory music. I can't even tell you one song, to be honest. The financial impact of Miss Pete's emotional and mental pain and suffering ultimately will be an amount to be determined at trial in excess of $75,000, exclusive of costs, interest, and fees. In addition to this harm, Miss Pete's reputation for honesty has been called into question by defendants' false and defamatory statements, not only in front of colleagues within the entertainment community, but in front of the public at large, including her millions of fans worldwide. As a consequence, Ms. Pete has suffered reputational harm that has affected and will continue to affect her both in her profession as a performance artist as well as future sponsorships and other business opportunities. Because if y'all didn't know, one, she opened up a rehabilitation center in Houston. So, she is doing stuff behind the scenes. So just imagine just walking down the street and somebody who, feeds into this false information, you know, could potentially harm you or, say something out the ways. Nobody should have to continue to live with that every single day. It's really sickening. It's really sickening. I wish more people would start suing folks because it's not about the money. It's not about, you don't have to sue somebody for money. You can sue, you can do a declaratory judgment and you can ask for something. You can say whether I want them to take down all their social media or not mention my name ever again. Whatever the case may be, it doesn't always have to be money. But if you suffered like emotional damage and you had to go to the doctor and you spent money or whatever the case may be, you had to come out of pocket to get your health together, yeah, I'm gonna make somebody else pay for that on top of requesting that you never be on social media ever again. So more people need to take heed of that. It's not all about money in a lawsuit. You can do other things. All right, so here are the causes of action. Count one, defamation. Defendant published a series of false and defamatory statements of fact of and concerning Ms. P to third parties such as subscribers, viewers, and followers on her social media accounts. First, defendant published false and defamatory statements accusing Ms. Pete of the crime of perjury and of a rigorous dishonesty and falsely accusing another of a felony. Specifically, here is what Cooper said. At the end of the day, a BITC BITCH lying on somebody is low down. Yes, she got hurt, and that's cool. But how did you get hurt? How? And what are your circumstances? And what after that? So, itch, if you think I'm finna be sitting up here boo-hooing for a itch that played up in y'all face, not mine, because I always said her ASS was lying. Itch, I don't. You think I feel sorry for you, itch? I don't. The uck, a itch uck with my, okay, I done already read that. So these are the defamatory statements. So they went and they found defamatory statements, and this is what they put in here. Okay. Let me see. Defendant's false statements regarding Ms. Pete's testimony at trial described above are defamatory per se. Was Megan Thee Stallion caught trying to deceive the courts again? She never deceived the courts. Okay. She never the court in Mr. Peterson trial, the jury found it was unanimous. It was unanimous. It was unanimous. It was unanimous. There's no other way to put that. All right. So everything that she said about, Megan lying in the courts, saying that she was gonna slap her and all this other stuff, talking about her father and all these other people who are addicts and all this other stuff, all of that is defamation. Um, ooh, I like this. Defendant, I'm gonna reread this, all right. Defendant's false statements regarding Ms. Pete's testimony at the trial described above are defamatory per se because they charge Ms. Pete with committing an infamous crime. All right, so when you go on the stand and you lie, that is a crime. That is a felony. Okay. A reasonable reader or listener of defendant's statements that Ms. Pete was caught trying to deceive the courts again and otherwise lied, fabricated, or falsified her testimony during the trial regarding Mr. Peterson's use of a firearm or her wound from the firearm would understand them as charging her with perjury, which is a third-degree felony in Florida and an infamous crime. That's number one. The false statements described above are also defamatory per se because they tend to subject Miss Pete to hatred, distrust, contempt, and disgrace. A reasonable reader or listener of defendant's statements would understand them to mean that Miss Pete falsely accused Mr. Peterson of committing felony assault with a firearm and gave untruthful testimony that resulted in Mr. Peterson's wrongful conviction, which is a despicable manipulation of the justice system and would garner hatred, distrust, contempt, and grace from the public. Finally, defendant's false statements described above are defamatory per se because they tend to injure Ms. Pete in her profession. A reasonable reader or listener of the defendant's statements regarding Ms. Pete's egregious dishonesty is falsely accusing another of a felony would view Ms. Pete as untrustworthy and may hesitate before entering into a professional contract with her. 95 reads, second, defendant published false and defamatory statements that stated Miss Pete was or is mentally incompetent and required a guardian. So remember what we was reading about that. And then she said that um and she's probably effing her guardian as well. That's false, and that is defamatory statements. I'm not going to read what she said because we already went over that, but I'm going to explain it. So, defendant's false statements regarding Ms. P's purported mental incompetency, are defamatory per se because they subject Ms. P to ridicule and disgrace. A reasonable reader or listener of defendant's statements that Miss Pete was legally retarded, I hate that word, slow, or required a guardian would come to ridicule Miss Pete. At it implies Miss Pete is unable to care for herself and requires round the clock medical assistance, which would also subject her to disgrace. Such statements are directly injurious to Miss Pete's personal reputation. Defendant's false statements described above are also defamatory per se because they tend to injure Ms. Pete in her profession. A reasonable reader or listener of defendant's statements, Ms. Pete was legally retarded, slow, or required a guardian, would view Ms. Pete as unable to manage or sustain her career as a mainstream and high functioning performance artist, causing harm to her professional reputation. Let me see what she said. Conspiracy culture is the worst thing that happened in the black community. Tell me about it. She did say probably though. I can't. Oh my gosh. Third, defendant published false and defamatory statements that stated Miss Pete was an alcoholic. All right, so it's telling you. So the first one was da 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 da. So the first false and defamatory statement, she was accusing her of committing a crime of perjury and egregious dishonesty during the trial. The second was her stating that she was mentally incompetent and required a guardian. And the third one is, let's see, that she was an alcoholic. So remember what they was talking about? She was a drunk or alcoholic, and she comes from a family of alcoholics. That's false, and that's actually defamatory because of what you said. Defendant's false statements are defamatory because they tend to subject Miss Pete to hatred, distrust, ridicule, contempt, and disgrace. A reasonable reader or listener of the defendant's statements that Miss Pete is a drunkie who comes from a line of alcoholics would come to hold Miss Pete in hatred, contempt, and disgrace. And it falsely implies that Miss Pete is an alcoholic who has a serious addiction that requires professional help. They are also defamatory because they tend to injure her in her profession. A reasonable reader and listener of defendant's statements regarding Ms. Pete's alleged alcoholism would view her as completely uh, unable to perform any of her duties as a mainstream performance artist and causing her professional reputation harm. Let's see. Defendant's false and defamatory statements caused Ms. P to suffer and incur both presumed and actual damages, including loss and injury to her business, insult, pain, embarrassment, humiliation, mental suffering, harm to Ms. Pete's name and reputation, out of pocket loss, other actual damages in the amount to be determined at trial, but in no instance less than $75,000. So it's not saying that she's asking for nothing like $75,000. That means it's going to be in excess depending on whatever the jury sees fit. Defendant acted with malice and or reckless disregard for the truth for the following reasons. So I'm not going to go through all that. This is just really talking about let me see how they accused her of lying under oath. They stated that she did not suffer from the pow wound and that the pow was lost. What else? Oh yeah, and that, let me see. Defendant promoted her false and defamatory statements due to her conspiratorial relationship with the Petersons, wherein she acts as a paid mouthpiece to spread misinformation on behalf of Mr. Peterson while he serves his 10-year prison sentence for criminally assaulting Miss Pete. Defendant implied that she is still on payroll. And remember that the judge, not the judge, the court, or the who am I trying to say? The plaintiff's attorney, Megan's attorney, has the calls from the jail. And in that call, I think Tori was speaking to, I think, was it his father? And pretty much along the lines, and this is not verbatim, that, they can't find out that, whatchamacallit is doing all of this for them. So that is an indication right there that y'all either hired her to do all of this, or there's some type of relationship there where she feels that she has to do it on y'all behalf. But either way, y'all got caught. Um, defendant published and reiterated the false and defamatory statements out of the desire to gain notoriety, generate revenue, profits for herself, and hurt Miss P emotionally. What it says, indeed, defendant's social media following has grown, topping over 100,000 followers across her social media accounts. She talks about her having a mental competency and alcohol problem. She has this demonstrated ill will towards Miss Pete. Like, she really don't like this girl. And I think if that declaration never came out from the senior officer at the LAPD Property and Evidence Department, she would still be running out doing this. Defendant lacked reasonable grounds for any belief in the truth of her statements and acted negligently in failing to determine the true facts. As a direct and proximate cause of defendant's defamation, Miss Pete suffered substantial, presumed, and actual. Corey, can you make sure you're not loud? Can you even hear me? Because you yelling. All right, thank you. All right, yeah, Um, Ms. P suffered substantial, presumed, and actual damages and loss, including but not limited to pain and suffering, emotional distress, trauma, insult, anguish, stress and anxiety, public ridicule, humiliation, embarrassment, indignity, permanent damage and injury to her personal and professional reputation, loss of business and income, attorney fees, costs, and other out of pocket expenses in the amount to be determined at trial, but nothing less than $75,000. Mm-hmm. Count two: promotion of an altered actual depiction. So remember when she altered that deep fake video? That's cause number two. It was a digital, electronic, mechanical, and or other modification, alteration, or adaptation that depicts a realistic version of Miss Pete with a computer generated nude body parts, presented as a nude body part of Miss Pete engaged in actual conduct as defined in Section 87 of the Florida statutes. She did not participate or engaged in at all. So they just violated a statute by doing this. She promoted this video online on social media. I just told my child to shut up and he's still um so she, I don't know. I think somebody sent it to her, but whatever the case may be, you still redistributed that video over and over and over again. Other people liked it, other people shared it. And then next thing you know, it spreads like wildfire. So it is against the law in Florida to do such things. And we already went over this in the previous complaint, so I'm not going to go over so that part. Count number three: intentional infliction of emotional distress. Now, mind y'all, in Cooper's motion to dismiss, the biggest thing she tried to get this case dismissed is saying that Megan really didn't state a claim in any of her complaint or in the first complaint. So that's why we seen the breakdown of the causations of action. So count three: infliction. I'm trying to look at my whatchamacallit. Hold on, turn this off. All right. So intentional infliction of emotional distress. Defendant engaged in extreme and outrageous conduct against Miss P. Defendant defendant's extreme and outrageous conduct consists of coordinating with Mr. Peterson, the convicted assaulter of Miss Pete, and a felon, his father, Sunstar Peterson, and Miss Peterson's attorneys to promote, distribute, spread, promulgate, communicate, and decimate. If the attorneys have something to do with that, that's crazy too. You have to hold yourself to a certain standard when you are attorney and you have a license with that particular state, because you can put your bar license at jeopardy. Mr. Peterson's false and disproven theories about Miss Pete while Mr. Peterson serves a 10-year prison sentence. The false and disproven theories defendant has spread on behalf of Mr. Peterson include, we already talked about that there was no firearm that was recovered at the crime scene. The LAPD misplaced it. Mr. Peterson did not pow Miss Pete, and Miss Pete did not suffer a bullet wound. Um, but she actually injured herself by stepping on glass. Uh, defendant's conduct is extreme and outrageous because she acted on behalf of the convicted felon to spread the misinformation described above in order to harass his victims, all while receiving a financial benefit from Mr. Peterson. So she was getting paid to do this. Defendant has implied that she is still on Peterson's payroll. All right. So that means that you have indeed accepted payment to whatchamacallit. So, and if you don't do it, then you don't get paid. Hold up. Decorius Michael, shut up. Because I still hear you. All righty. In one phone call, the Petersons confidently asserted that Miss Pete would be unable to prove that Mr. Peterson paid defendant for attacking Miss Pete. Further, on information and belief, defendant also coordinated with the Petersons to employ online bot accounts to attack Miss Pete and her supporters with hateful, derogatory, and malicious statements on social media. A lot of people don't realize that's when you get to subpoenaing certain places and you're obtaining certain records, and people like myself, a paralegal and legal assistant an attorney will have to sit down and go through page after page after page to trace something. It will be found. So they were doing too much at the end of the day, because I'm pretty sure they probably getting bank statements to see the bank transactions from either Tori's daddy or whoever to pay her. All of this crap about to come out. This case is about to be so freaking juicy. Now, unfortunately, when it comes to discovery, we won't be able to see any of that information because that's exchanged between the attorneys. But I'm pretty sure something gonna come out. Something is gonna come out. Defendant's conduct described above is extreme and outrageous because it goes beyond all bounds of decency and is regarded as shocking, atrocious, and utterly intolerable in a civilized community. Defendant intentionally and or with reckless disregard of the high probability caused Ms. P to suffer severe emotional distress. Defendant knew and or should have known that the statements she shared on behalf of Mr. Peterson was false, untrue, debunked, and meritless. Indeed, look at this. Look at this. Indeed, on November 19th, 2024, defendant finally acknowledged that the falsity of her statements and shared the truth with her followers, stating, and I'm going to repeat this: from this day forward, today is November 19th, and the public has made aware of this form. And the form that she's talking about is the lawsuit that she got. Because with the lawsuit came the declaration. Oh, wait. No, I think he did the declaration a little bit after. But whatever, the form is the declaration. She read the declaration from the senior officer of LAPD stating that they have the pow, the bullet fragments, the magazines, and the bullet casings. So it took all of that for you to finally acknowledge that you lied about the pow being missing. You done started all this. And if no lawsuit was ever filed against you, you would have carried on. I wonder what Tori's thinking now. Like, I paid you to put out this information. Now look. Defendant knew and should have known that her extreme and outrageous conduct would have caused Miss Pete to suffer severe emotional distress. Defendant knew and should have known that Miss Pete was susceptible to severe emotional distress regarding the false and disproven theories defendant shared on behalf of Mr. Peterson. Yet, defendant spread those theories nonetheless. Defendant was present for the trial and heard Miss Pete's testimony. During her testimony, Miss Pete stated, so Cooper heard her say this, because I was pow-powed, I've been turned into some kind of villain and he's the victim. This has messed up my whole life. The whole situation in the industry is like a big boy club. I'm telling on one of y'all friends. Now you all about to hate me. Miss Pete further testified, I can't even be happy. I can't hold conversations with people for a long time. I don't feel like I want to be on this earth. I wish he would have just pow and unalived me if I knew I would have to go through this torture. She also testified to suffering from suicidal thoughts since the pow-powing. More recently, Miss Pete stated publicly that she would rather not live through this than to have to live with this, referring to the false theories defendant has spread on behalf of Mr. Peterson. As such, defendant knew and should have known that her continued false statements regarding Miss Pete and the trial would and did cause Miss Pete severe emotional distress. As a direct and proximate cause result of the defendant's extreme and outrageous conduct, Miss Pete suffered substantial presumed and actual damages and loss, including but not limited to pain and suffering, severe emotional distress and trauma, insult, anguish, stress, anxiety, public ridicule, humiliation, embarrassment, indignity, permanent damage, and injury to her personal and professional reputations, loss of business and income, attorney fees, costs, and other out of pocket expenses in the amount to be determined by trial. Count 4. This is a good one. Cyberstalking Injunction Relief. A lot of people need to pay attention to this section. Defendant has communicated both directly and indirectly a course of conduct designed to cause emotional distress to Ms. P as laid forth herein. She has done so through electronic means and therefore meets the definition of cyber stalking pursuant to Section 784.048 of the Florida statutes. Accordingly, she is entitled to an injunction against cyber stalking pursuant to that statute in Florida. Ms. P incorporates by reference the attached affidavit as required by statute. Ooh, ooh. First of all, okay, hold up. I want to see what this statute is. See, that's why I said it is more to a lawsuit than just getting money. And once I read this, then we can finish it because it's going to break down. So, Florida statute. Oh crap! I ain't even sharing my screen. Hold on, I got y'all. Let me make this bigger. All right. So if y'all can see this, so Florida statute 784.048 defines stalking, its penalties, and other related terms. So stalking, the act of willfully, maliciously, and repeatedly following, harassing, or cyber stalking another person. Harassment, a course of conduct that causes substantial emotional distress to a specific person and serves no legitimate purpose. All right, this is what I'm looking for. So, cyber stalking, the use of electronic forms of communication to harass a person or to access or try to access their online accounts or home electronic systems without their permission. So, cyberstalking is the use of electronic forms of communication to harass a person. That is what cyberstalking is. So everybody knows the term. Let's go back to the complaint. So we're going to read the affidavit shortly. Wherefore Miss Pete seeks an injunction restraining defendant from committing any acts of cyberstalking against her and providing any terms the court seems necessary for the protection of Miss Pete, including any injunctions or directives to law enforcement agencies. So what she did, she can no longer say anything about Megan on her freaking on any platform. She can't say dilly squat about Megan because that's going to be considered harassment. So she is asking for, I need to see if they went ahead and filed like a temporary injunction. But yeah, she's entitled to an injunction against cyber stalking. Cyber stalking is harassing somebody online. That is what that is. I don't know. I'd be feeling like my screen is going off. Hold on. Let me get her affidavit because the affidavit was actually attached. Let me see. Yep. Exhibit A. Ooh. Ooh. I'm so wait, hold on. Let me just make sure there's no other all right. No personal information on here. I love it. I love it. I wish that people take this route. All right, so here's Megan Pete's petition for injunction against stalking, cyber stalking. So it says the undersigned petitioner, Megan Pete, declares under penalty of perjury that the following statements are true. Petitioner resides at blase blase. Respondent resides at blase blase. Um, Respondent's last known place of employment is unknown. Physical description of the respondent: a female of medium build with long dark hair. Race black, sex female, date of birth unknown, height unknown, weight unknown, eye color unknown. Oh no, eye color brown, hair color brown. Distinguishing marks or scars unknown. Aliases of respondent: Milagro Gramz or Mob's World. C, it says no other causes of action currently pending between petitioner and respondent, nor have there been nor have there been previous attempts by petitioner or respondent to obtain an injunction for protection against stalking in this and any other circuit. Petitioner is a victim of cyber stalking because respondent has committed cyber stalking. A description of facts regarding respondent cyber stalking are set forth in the amended complaint to which the petition is attached. So they're talking about what we just read. Petitioner seeks an injunction immediately restraining respondent from committing any acts of stalking and providing any terms the court deems necessary for protection of a victim of stalking, including any injunctions or directives to law enforcement agencies. I love it. Hold on, let me turn my night light off. Ah, da, 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 da. All right, cool. Under penalties of perjury, document and that the facts stated in it are true. I understand that the statements made in this petition are made under the penalties of perjury, punishable as provided in section 92.525 of the Florida statutes. And that is it. So we have seen, I don't want to say samples, they're not samples. We have seen where Milagro has defamed her. Um, she has put out this narrative that Megan has lied under perjury. I'm sorry, lied under perjury in court during trial, which is a third-degree felony. She has put in the atmosphere that Megan is an alcoholic. She has put out there that Megan is I do not want to say that word. She's slow and she needs somebody to take care of her. And she has put out these statements to all of her followers. And they have attached themselves to that and have further spread this misinformation, this false misinformation to over thousands and thousands and thousands of people. And people are soaking it up because they're being brainwashed and they're believing it. So not only is Megan suing for defamation and cyberstalking and intentional infliction of um, emotional distress, as well as the actual depiction with the deepfake video, she's asking for an injunction of cyberstalking. She's asking the court to grant this immediately so that this girl cannot say shit else about her. I'm going to cuss on this one. So she can't say nothing else about her. So I'm about to go to her other pages and I want to see if she has mentioned anything about Megan in regards to this. This is how you shut somebody up. It's not about the lawsuit itself. It's about this injunction right here. She got you for cyber stalking, harassing her, spreading false lies. So I want to know exactly if they went ahead and granted this injunction. I sure hope that they did because it's needed. A lot of people out there need this because people are continuously running their mouths with misinformation and thinking that nothing will ever happen to them until you find yourself in court. So that's the end of that. I'm glad I did it in an hour. Yay. But y'all definitely tell me what y'all think about this one. I am very happy to see when somebody is, harassed online that they take matters into their own hands and they make an example out of somebody. And that's all you need to do. There's no reason why people should sit here and continuously spread misinformation. But it's even sadder when you have people that's soaking it up but refuse to do their own research and refuse to have a mind of their own. The internet is accessible. But y'all let me know what y'all think about this case. I'm about to be out of here, enjoy my kids. It's about to be break. One thing I do want to say, it is December. And so I'm not going to be on YouTube or social media as much because I have to get my books under control for my businesses because I like to do that before December 31st because come tax time, everything needs to be flowing. So I got to balance my books and help these attorneys get out whatever cases they need to be done. So I'm going to be busy. But if there's any new information on this case or any other case, I will definitely keep you guys updated. But tell me what y'all think about this Megan versus Cooper lawsuit. Do you think that it is proper for Meg Thee Stallion to get an injunction against Cooper? And has she even, since this petition, I didn't close the petition. Let me see. Since this amended petition has been filed, yeah, I didn't close it out. That's okay. Do you believe that she should be entitled to an injunction? Because I hope this girl have not been talking about her since she has received this amended complaint. But y'all let me know what y'all think about it in the comments below. Don't forget to like, share, and subscribe to this video. Until then, you all be blessed. Have a good night, and I'm out. Bye.